Welcome everyone to our 21st webinar. I'm Michael O'Donoghue and I'm the Marketing Manager at ISL. Today we'll be covering partner visa changes as announced in the Federal Budget 2020 to 2021. More specifically, an introduction to English language requirements for applicants and Australian permanent resident sponsors, how to request for an extension of the last entered date on a subclass 309 visa, the importance of entering Australia before subclass 300 visa expiry, and updates to the partner visas during COVID-19 pandemic. I'm joined today with two of our speakers, Anne O'Donoghue and Lahini Kanara. Anne is one of the top 5 immigration lawyers in Australia and has over 40 years of experience in the legal profession, over 26 years of which specialising in immigration law. Anne has been an accredited specialist since 1998 and is finally an internationally renowned lawyer and active member of both local and global associations of law. Our second speaker, Lahini, was admitted as a solicitor in the Supreme Court of New South Wales in March 2019 and currently holds a practicing certificate in New South Wales. Lahini started at Immigration Lawyers in 2019 and is currently the team leader for the family stream. Lahini graduated from the University of Sydney in 2017.
Introduction, and I would like to speak today on partner visas, and I'm delighted to be joined by Lahini. And we'll just give a quick run of the different subclasses in case you missed our previous partner visa webinar. There are basically 6 subclasses: subclass 300, which is the prospective marriage; the 309, which is the partner visa, which is offshore, which converts to the permanent class 100. Both of these are offshore. Onshore 820, which converts to an 801 onshore, and the partner main requirement is that you must be in a genuine relationship with your spouse or de facto partner who's an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. Now, of course, the impact on travel bans on partner visas have been immense. We've seen so many different types of scenarios where people are caught and their plans have been changed. Now, the partners subclasses 100, 309, 801 and 820, and child subclasses 101, 102 and 445 visa holders can come to Australia. If you're a spouse or a de facto partner of an Australian citizen and hold a temporary visa, you are available to come to Australia. Exemptions requests are made online. We've just had a technical little glitch just at the moment. We're getting back. I apologise for that. Now, exemption requests are made online through the Department of Home Affairs website. You should attach proof of your marriage certificate, evidence of your de facto relationship, such as a shared finances or property, your birth certificate or birth certificates of your children. Do not travel until the department advises that you can. It's not the end of the road if you don't have sufficient evidence of your relationship. You can apply for travel under compassionate or compelling reasons to Australia. The ground is challenging to satisfy, and we recommend using professional help as it requires substantial evidence of the compassionate reasons to travel. We see a lot of people that have done their own travel exemptions applications, which they feel is very meritorious, but when we look at them, they're not well documented, and that's often reason when a new application or a request has to be made. I've heard of cases of people being refused 3 or 4 times. The practice has been very fortunate that we're getting a high level of our travel exemptions approved at the first instance. Now, the migration trends in Australia based on recovering, the Australian economy recovery really, The effect of COVID-19 has severely impacted net overseas migration. It is expected to fall from 154,000 people in 2019 to a negative 72 by the end of 2021, before gradually increasing to about 201,000 in 2023. Minister Alan Tudge has also stated that since the start of the year, we've had about 300,000 fewer temporary migrants in the country. ABC journalist Dr. Shane Gerhard has stated that since the beginning of the year, we have lost almost 2 years of population growth in just 3 months. Of course, there's the financial and economic imperative to start things moving again, which is certainly pressing on many sectors of the economy, and it affects migration substantially. It is likely that Australia's recovery plan will focus on an increase of the population. The country's population growth will drop to just over 0.2% this year, the lowest rate in more than 100 years due to the international border closures and slow fertility rate. It is evident that Australia will aim to focus its migration trend on attracting skilled migrants and partner visas to encourage financial stability and increase population growth, respectively. Now, the impact of the 2020 to 2021 federal budget on immigration within Australia. The federal budget 2021 was announced on the 6th of October. The current cap of 160,000 will stay in place. However, we'll have a heavier focus on family stream options with an increase from 47,732 places to 73,300 places. This will be applicable for the 2020-21 migration program only and can be expected to return to the lower cap next migration program. Employer-sponsored global talent business innovation and investment program visas will be prioritised within the skilled stream. And of course, there is an allocation of 15,000 places for that particular visa. Out of the 77,300 places available to the family stream visa applicants, 72,300 of those will be allocated to partner visas. So there is a high priority for partner visas in these circumstances. If I could have the next slide, please. We don't want any more technical hitches, that's good. Now, this slide that's just come up on screen is the migration program planning levels that I did discuss before. The family total is what I stated, and the majority of that will be allocated to partner visas. I think it's representative of 81.66%, but there has been a drop in parent and other family categories. So now the changes to the sponsorship requirements. The government will apply the family sponsorship framework to partner visas, which will mandate character checks and the sharing of personal information as part of the mandatory sponsorship application and subject the sponsor to enforceable sponsorship obligations. Now, this is a first for the partner visa category. The sponsorship framework will require partner visa sponsors to be approved family sponsors before partner visa applications can be lodged. These changes have been introduced to reduce the risk of family violence following the lodgement of the visa subclass. These changes will complement existing family violence provisions within the partner visa program. If I could have the next slide, please. Media releases by Alan Tudge on the 14th of October. We will require sponsors to agree to certain results of their character checks being shared with their partner prior to the visa application being lodged. This may include information indicating a potential threat, such as charges and convictions of a violent nature. This ensures their partner can make an informed decision about whether or not to proceed with the visa application, especially in circumstances where children are involved. It also means applicants can feel empowered to walk away from a potentially violent relationship based on information shared before they lodge and pay for their visa application, because a partner visa is a substantial capital investment apart from the emotional investment, and people need to be well informed of the circumstances. And in some cases, if they need to be able to walk away, they need to do this. Now, the character requirements for sponsors should not have a significant criminal record in relation to relevant offence. A relevant offence is an offence involving any of the following: violence against a person, including murder, assault, sexual assault, or a threat of violence, the harassment, molestation, intimidation, or stalking of a person, the breach of an apprehended violence order, or a similar order issued under a law of a state, a territory, or a foreign country, firearms or other dangerous weapons, people smuggling, human trafficking, slavery or slavery-like practices, including forced marriage, kidnapping, or unlawful confinement. And this is quite an emerging trend in the human trafficking, modern slavery area. And as my understanding, agencies want to work together to move towards convictions in relation to, or at least identification, investigation and convictions, so that this horrible issue of modern slavery can be certainly dealt with in a fulsome way. Now, addressing character issues of the sponsor. Despite a sponsor's character, the department may decide to approve the sponsorship if the department considers it's reasonable to do so, having regard to the following: the length of time since the sponsor completed the sentence for a relevant offence or relevant offences, the best interest of the following: any children of the sponsor, any children of the applicant who are seeking to satisfy the primary criteria for the grant of the visa concerned, and the length of the relationship between the sponsor and the applicant who is seeking to satisfy the primary criteria for the grant of the visa concerned. Now, the English requirement is again a new initiative. The government will introduce the English language requirements for partner visas applicants and their permanent resident sponsors. The Minister's office has confirmed that the new language requirements would not need to be met until applying for the permanent resident stage, which is usually after 2 years from the date of the subclass 820 or 309 visa being lodged. These changes will help support English language acquisition and enhance social cohesion and economic participation outcomes. The applicant and permanent resident sponsor will be required to have at least functional English or have at least made reasonable efforts to learn English. I can foresee with these applications for reasonable attempts to learn English, it'll be like an argument that you'll be putting forward to satisfy this requirement, which I think will involve immigration lawyers in yet another type of scheduled or compelling argument in these circumstances. But of course, time will tell as we start working with the new legislation. To prove you have functional English, you must provide evidence that you are a citizen of and hold a valid passport issued by the United Kingdom, the USA, Canada, New Zealand, or the Republic of Ireland. Your English has been assessed as functional by the Australian Adult Migrant English Program service provider, or you have completed a degree, a higher degree, a diploma or trade certificate in an institution in or outside Australia that requires at least 2 years of full-time study and all instructions were in English. Now, the requirements to functional English, or you undertook your education at, which is basically they're talking about a primary school, secondary school, where instruction was in English in or outside Australia, all years of primary and at least 3 years of secondary study. A secondary school in or outside Australia where instruction was in English, at least 5 years of study. An institution in Australia where all instruction was in English, at least 1 year of full-time study towards an award, or an institution in Australia where all instruction was in English, a part-time equivalent of 1 year of full-time study towards the award. Or in the 12 months before you applied for the visa, you scored one of the following, which is the IELTS test, an average band score of 4.5 based on 4 test components, or the TOEFL, a total band score of at least 32 based on 4 test components of speaking, reading, writing, and listening, or the Pearson test of English academic, PTE, an overall band score of at least 30 for each of the 4 test components, and the Cambridge English Advanced CAE, an overall band score of at least 147 for each of the 4 test components. Prioritising regional visa applications, partner visa applicants, where the relevant sponsor resides in a designated regional area, will also be prioritised in the 2021 migration program. This is to encourage migration to regional areas of Australia. The following postcodes are included as a designated regional area in New South Wales. So in New South Wales, regional centres are described. I mean, they're like, for example, Southern Highlands, Bowral, which can be just no more than a 2-hour drive from the Sydney CBD. Now, we're now going on to further immigration updates during COVID-19, and I will hand over to my colleague, Lahini, who will go through this material now. There may be just a couple of minutes while we connect, but Lahini should be online very soon.
Thank you, Anne. Thank you, Anne. Can everyone hear me now? Okay. So as Anne said, it's very important to make sure that the partner visa is lodged before these new changes come into effect next year, especially someone who has a sponsor character issue. If your partner has a character issue, you should make sure that you lodge your visa application before these new changes come into effect. And also with the regional requirement, if you're living somewhere regional, make sure that you update your address on the applications to reflect that, and you can also do a cover letter to bring the attention of the case officer. Okay, so moving on, this slide is looking at condition 8504, which is attached to subclass 300 and 309 visas. So subclass 300 and 309 visa holders will have to make a first entry date by a certain date. The department has stated that they will provide facilitation letters for subclass 309 or 300 visa holders if they're unable to enter by the first entry date. These facilitation letters are provided where exceptional and compelling reasons have prevented holders from entering Australia. Circumstances around COVID-19 and travel restrictions will be taken into account as compelling. You can now request for this facilitation letter by submitting a travel facilitation request form on the department's website. If you were granted a travel facilitation letter, bring it with you to your departure port. You must present it at all check-in and on arrival in Australia. So in addition to the first entry date, if you're on a subclass 300 visa, your visa will expire within 9 months. Once a subclass 300 visa has expired, there is no provision to extend the validity of that visa or provide an applicant a letter of facilitation to allow entry into Australia after the visa has expired. The government has announced that prospective marriage visa holders will be able to access a government fee refund if they can't enter by that visa expiry date. However, our advice for 300 visa holders are to apply for a travel exemption and to enter Australia before that date. If we can go to the next slide, I'll just chat about a recent case that we have managed. So in this situation, our client was granted a subclass 300 visa on 14th February 2020 with the initial enter date by 14th November 2020 and a visa expiry of 14th November 2. The department was obviously willing to provide a facilitation letter to extend the first entry date, but they were not able to extend that visa expiry date as there are no migration provisions to extend the validity of a visa. And when our client came to us, they already had to refuse travel exemptions. This is because just because you're holding a subclass 300 visa, you're not automatically exempt from the travel ban. So you have to apply and get that permission, and they've already refused 2 travel exemptions. We then took over and lodged a travel exemption on behalf of our client with evidence of them registering their de facto relationship and with evidence of urgent need to travel. So fortunately, her travel exemption was approved on 19th October 2020, and our client entered on 28th October, completed quarantine on 11th November, and then got married on the 11th. And then we were able to lodge an 820 visa application by 12th November before the visa expired on 14th of November. So it was a happy result in the end where the applicant was reunited with the sponsor, and now she's able to remain in Australia with full permission to work and study. Next case study, please. Okay, so this one looks at a client who was holding a 309 visa with condition 8504. So our client and her son were granted the subclass 309 visa on 16 January 2020 with a first entry date by 16 January 2021. She was unable to enter Australia due to the current global pandemic, and also she's from Russia, and the flights from Russia were extremely limited. In addition, she didn't want to take the risk traveling with a minor son. So we requested a facilitation letter from the department based on compassionate reasons for breaching that condition by not entering Australia before 16 January 2021. And then our client was granted a facilitation letter that extended her first entry date by further 12 months. So again, she now has time till end of next year to make her arrangements to enter Australia. Next slide, please. Okay, so we'll just now go through general updates. So the ETA is now open again. The department has reopened ETA applications to eligible countries. You can apply for ETA via the mobile app. So the eligible countries are Brunei, Canada, Hong Kong, Malaysia, Japan, Singapore, South Korea, or USA. So if you have a passport from those countries, you can now apply for the ETA. However, you still need a travel exemption approved to enter the country. So if you are a partner who has lodged a partner visa, if you are from one of these countries, you can now lodge an ETA. And if you have evidence of either being married or a relationship registration certificate, you can apply for a travel exemption and enter the country. Another interesting update is that the department has removed the processing time for 300 visas. So the current priority the department is giving to offshore family programs where immediate family members of Australian citizens and permanent residents are involved. So holders of prospective marriage visas are not considered immediate family members of an Australian citizen or a permanent resident, which is why it's very important to get that de facto relationship registered so that you have evidence to make you an immediate family member of an Australian citizen. The department also announced the New Zealand travel zone, where from 16th October 2020, you can travel from New Zealand to Australia quarantine free. If you have been in New Zealand for 14 days or more and not being in a designated hotspot, you are able to travel to Australia on a quarantine free flight. You do not need to be a New Zealand citizen to travel to Australia if you meet the above criteria. So again, if you're a partner in New Zealand and you have lodged a partner visa and you're looking for a way to come to Australia, you can now apply for a visitor visa and come into Australia if you are not a New Zealand citizen, and you don't need to quarantine. Next slide, please. Okay, so these are just general updates within Australia. As everyone is now aware, there is a new cluster in South Australia, and they have the South Australian government has suspended international flights from until 22nd of November 2020. And the border between Victoria and New South Wales is going to be open from 23rd November 2020. And the Queensland New South Wales border will also be open, and you can enter New South Wales if you have a valid Queensland border declaration pass. But you can't enter if you are from one of the 32 Greater Sydney areas that is identified on the next slide. Next slide, please. Yep. So these are the suburbs that if you live in these suburbs, you really can't travel between Queensland. Okay, so that brings our webinar to an end today. If anyone has any questions, this is a good time to ask them.
Hello? Hello? Hello?
Yes, we can
Yes.
hear you.
Yeah, just a quick question.
Yeah.
Okay, now I've submitted, like I'm the spouse for, like I'm sponsoring my partner that's overseas in Lebanon under a subclass 300, visa. Now I've submitted it in April this year. We've done all the requirements. We've done everything. I've used a immigration agency, and he's done everything for me. Now we've just finished that. We've done her medical, and they've asked for her VFS biometrics and all that. And I'm just waiting for an answer. Like, what do I do now? Like, because I'm just waiting. Like, I go back to my agent, and he says to me that he just says to me that, we've got to wait for Home Affairs to reply back to him. Like, is it like a case where they have to send us a case officer, or how does it work from here? Because we've done everything right. Like, we don't hear nothing from Home Affairs.
No, I certainly sympathise with you in these circumstances. It is a difficult situation. We've just got a little bit of a sound problem. We're trying to fix that at this moment. If you could just deal with it. I think we've fixed the sound problem. I came in on, what are your initial thoughts on that, Lahini?
Okay, so a new development is that the visas are now not being processed in Lebanon. So if you have applied from Lebanon, it has actually moved to Jordan. So corresponding with the processing center in Lebanon is not going to help you. You need to be communicating with the processing center in Jordan. And so I think you can request for expedited processing, or your best option is getting a visitor visa through and coming here on a visitor, getting a partner here on a visitor visa.
Okay, then. All right, that will be all right. A visiting
How long
visa.
has 300 been processing at the moment for you?
Sorry, say that again.
How long has the class 300 been processing at the moment?
Well, we've submitted it in April. So April this year, 2020.
Yeah.
It's not a particularly, I know it's very difficult to be apart from your partner, but it's not a particularly long period of time when you look at the previous processing issues. And also it's a concern with Lebanon at the moment, but I definitely know that everything is being processed through Jordan. But I agree with Lahini. I would be looking at a visitor visa possibility with a travel exemption, and trying to get in that way, unless, of course, your agent can make contact with someone at a senior department level in Canberra and then have a look at where this case is at. That's also a possibility.
Okay, all right, that's helpful. Yeah, okay. So what's the visitor's visa? What's that called? Is there a number for it, or like a subclass number?
Yeah, it's subclass 600.
600. I mean, there's quite a few, but it's tricky. Not all visitors' visas are approved. You really should, if you're going to go down that route, I suggest that you obtain some independent immigration advice on that. And perhaps, did your migration agent suggest that option to you?
He did. But going through COVID, at the end he said to me like that they've stopped visiting visas because of COVID. So they're allowing only students and work visas and partner visas. That's what they're allowing at the moment.
Experience. We've got quite a few visitors visas approved for people in these types of circumstances. Of course, every case turns on its own particular fact situation, but perhaps you might be better going back to your agent and seeing if you could look at other options, or alternatively getting a second opinion may be a good option for you.
All right. So yeah. So the you're saying the agent's in Jordan. The embassy.
The processing post is now in Jordan, as I understand it. The processing for biometrics and everything like that in Beirut has closed, and everything is being processed through Jordan. That's my understanding at the moment.
Right. I just thought I'd let you know last week it opened, the VFS Global. It opened in Lebanon Biometrics, and she went and did her fingerprints, and they took her photos in Lebanon after the
Well,
bomb blast.
that's happened, you know, in the last week or so. Things do change.
Yeah.
But I know there's been a lot of pressure politically on the numbers of people that are waiting on these types of visas, and especially because of the, you know, the explosion in Beirut, how people have been displaced, family members being concerned about their safety.
I agree, 100%, 100%. So what's in Jordan? So that's the main base now in Jordan, you're saying, is it?
Well, that's been my
Yeah,
understanding, but Lahini, have there been any other updates in the last week? There may have.
Yeah, biometrics can be taken in the country you're currently living, but the visa applications from Lebanon are being processed in Jordan.
Right. So, okay. So I just thought I want to recap that. So she's done her biometrics already and her medical and everything in Lebanon. It's all gone through. But now I should now go to Jordan and contact the Jordan embassy, the Australian embassy in Jordan, and speak to them on an update on where her application's going through her application ID. Is that correct?
That is correct. But
Right.
they're not going to.
I'd go to the Jordan Post. If things are resuming back in Beirut, the Jordan Post will tell you that.
Right. Okay. So is it like an email or something that is it like?
Look, you'll have to forgive us at this stage because we've got some other questions to answer.
Sorry, I'll leave you to it. No worries. Thank you so much for your help.
No, it's been a pleasure. I think we've got another question here. Is it possible to apply for a travel visa under compassionate grounds for the 820 when my partner is in Australia in the current pandemic? Lahini, would you like to start off with that?
Yes, so the most important thing, Sean, is to know where your partner or where yourself is from. So the country of passport, because as I said, the ETAs are now open. It's much easier to get an ETA over a visitor visa. But whatever you apply, you do need to show evidence of urgent need to travel. And for that, I think you should get independent legal advice, because there are certain documents that you need to provide to get the visitor visa looked at. And once the person comes to Australia, if there is no condition 8503 attached to the visitor visa, you can lodge an 820 in Australia. But even if there is an 8503 attached, we have been successful in getting those waived because of the pandemic and the inability to fly to where the person's from. So yeah, there is the possibility, but we obviously need more information. So I would recommend you booking a consult with us.
I'm just checking to see if there's been, because there were quite a few questions coming in, live questions. It's nice to have the live questions rather than have the just the chat box. Very nice. Thank you from Sean. We look forward to having a consultation with you too. So I think you'll find that we provide good services for the consultation. I think a lot of people really just want to be put in the right direction and get that type of confidence in the advice that they're being given, because it's a very stressful time if you think, with partners being separated and borders being closed, embassies closed. I mean, Beirut is a particular hotspot. A lot of people have suffered as a result of that, and I do know that there are flights from Qantas. I think Qantas has really been a good corporate Australian in bringing people home where it's possible to do so. And I think it's the highest priority for the government to get Australian citizens or permanent residents home. I'll just check. Lahini, have we got any other case studies you wanted to raise or any concerns?
Case studies, I mean, in relation to the condition that I spoke about, that was it. That's what we have handled. But we have obviously done a lot of travel exemptions and partner visas.
Yeah, I think we must have done at least 20 plus travel exemptions.
Yeah,
Today it's
not
success, but there's a lot of work involved in these, and it's just not a matter of going to the platform and downloading stuff. If you do that, it doesn't mean, and I was in a meeting not so long ago where I was told that it's quite common for people to get 3 or 4 rejections for these travel exemptions. Well, just imagine how those people are feeling each time they get another rejection and they're missing that partner or that family member. So what I'd suggest today is the benefit of getting independent advice and getting one opinion, or even getting a second opinion, or getting a third opinion. It's like a medical opinion. You know, you always get a second opinion, or if you're getting some work done on your home, you don't go for the first quotation, you get different opinions. And that's what I'd suggest to the audience here. Always get a second opinion.
Sorry about it, Anne, but we have a question from an anonymous attendee. They've said, I'm sponsoring my partner from Macedonia and have waited for close to 2 years. Will the new budget benefit our application? So I'll say that again. I'm sponsoring my partner from Macedonia and have waited for 2 years. Will the budget benefit our application?
Well, I suppose it also depends where the applicant is going in Australia, given the new changes. 2 years is quite some time. In these circumstances. It also depends whether the application is decision ready, whether there are any issues with the application. Has the applicant or the sponsor in this case made a request for expedition of the application to see where it is? A lot of these concerns are if the application's not decision ready and it's missing some vital material. A client may think, or an applicant may think it's decision ready, but it's not. Also, if there are any, have all the checks done, there may be some security checks concerns, these types of things. There are a whole range of issues that need to be considered in relation to, but what's the normal processing for offshore partner visas now? I thought it was around the 2 year plus. Lahini?
Yeah, it's around 17 months, but they keep updating it.
Okay, so anonymous, if you're watching this right now, it's not an easy answer. You're going to have to maybe come in and maybe find out more for your scenario.
But we totally sympathise for anyone who's been waiting 2 years for a partner visa.
Yeah, and with the budget, the budget did announce that they're giving more places for partner visa applicants. So that means the department wants to grant visas and wants to look at partner visa applications. So it's important to make sure it is decision ready and that it can be granted quickly.
And there is going to be preference to people in regional areas. So it looks good from the point of view of political will. Then we're just looking at the practicalities. Is the application in good shape? So it is decision ready. So it's capable of having an approval. So I think we're almost very close to our time, aren't we?
Yeah.
Time is running out. If you have any other questions, quickly let us know. Otherwise,
because I think we've gone over. Apologies for anyone if we had any technical issues. But this is the era of Zoom, and sometimes you do get some technical little glitches, but we've got a fantastic IT technical team here that are always willing to help us out if we have a problem. Will the new budget benefit our application? Well, in principle, I believe it will. And the new budget, I think, will benefit applications, but I stress that the applications need to be well documented. It needs to be a genuine relationship, because transparency and digital sharing of information this is the era now. And if you have got a problem in your immigration history past, it's better to disclose it than to try and sweep it under the carpet. Full disclosure is the way to go, especially in a partner visa application.
And just finally from Sean, thank you again for all your info. Thank you, Sean. looking forward to speaking to you, and to everyone else watching. Have a good day. I think we'll end it on, is that okay, Anne, if we can end it here?
Yeah, I'm fine. We were delighted to be able to present webinar 21, and we look forward to webinar 22, which I believe is on the business migration, which we all look forward to. So stay tuned. We'll
Thank you,
be with
everyone.
you in 2 weeks' time.
Have a good day.
Bye, everyone.